My name is Darlene Dreisch. I was granted full custody of my son Benjamin in my Lauderdale County, Alabama divorce in May 1998 when my son was 2 years old. Benjamin and I were in a car accident when we were living in Orlando, Florida in 2005, and I subsequently lost my job with the U.S. Census Bureau. On April 11, 2008, when we were living in Florence, Alabama, and my son and I were preparing to move to Maine, where my fiance and now husband George lives, we were served with custody papers. On that date, a grandparent had given a handwritten letter to an Alabama judge, Judge Jimmy Sandlin, asking him to help her prevent me moving to Maine with Benjamin. No petition, motion, or sworn affidavit was filed, though it is required per Alabama Code Section 12-15-52C, which states, "The petition shall set forth with specificity what the petition is asking, to include the facts regarding jurisdiction." Also, no filing fee was paid by the grandparent to open the case. Judge Sandlin's actions directly violated Alabama Code and UCCJEA law, as there is no evidence of neglect or abuse against me. However, facts of law and evidence did not matter to Jimmy Sandlin. In fact, here is the letter. This is all it takes to have your child removed from your custody in the state of Alabama and other states, as I've found recently. The Alabama Code also states that providing a showing of verified evidence of abuse or neglect, a hearing is required within 72 hours of issuance of the pickup order. In my case, no evidence existed, and the hearing was scheduled 12 days after the emergency pendant light order was issued on April 11th. Further, it wasn't an evidentiary hearing, nor was it a dependency hearing. I did not go before the judge, nor the judge or any attorney instruct me as to what was at issue, other than it was a custody case held in a civil court. We were never before a juvenile court, and Benjamin, my son, was never allowed to speak with the judge, nor allowed to speak at all. And Benjamin's own petition for a new GAL was promptly denied by Judge Sandlin. This is my son's petition. It is the only petition that was denied by the judge. All petitions by the grandparent and the GAL were approved by the judge. Due process errors by the trial court include denial of my right to cross-examine witnesses per Alabama Code 1221-137. I was not given notice of the final custody hearing, and the court dismissed my attorney and failed to appoint another counsel to represent me. Judge Sandlin held the final custody hearing in violation of the 1st, 5th, and 14th Amendments of the U.S. Constitution. In the case of Smith, 1991, 77 Ohio, citations omitted, permanent termination of parental rights is described as the family law equivalent of the death penalty in a criminal case, and parents must be afforded every procedural and substantive protection that the law allows. My son and I were denied all procedural and substantive protection when he, at 12 years old, was taken from me against all lawful provisions guaranteed by U.S. and state constitutional laws. Kidnapping by court action must be recognized as destructive and illegal as any other violent crime. I have not seen my son since September 2nd, 2008, when he was pulled from my arms in Bangor, Maine, begging to stay. I could not protect him. Excuse me. Judge Sandlin was voted out of office in July of 2010, but his unconstitutional ruling still stands. I love my son and ask that you help me bring my son home. Thank you.